Colleagues, friends, good evening and welcome. Thank you for joining us for this Rare Books lecture for 2023. My name's Matthew Harding. For those who don't know me, I'm the Dean of the Law School here. So to visitors of our law school, welcome and thank you for being here. Can I begin by acknowledging country? We meet this evening on the lands of the Wurundjeri people of the Kulin Nation. I want to pay my respects to their elders past, present and emerging, and I want to acknowledge their connection to country, custodianship of country in this place for thousands of years. This lecture is delivered by a very interesting scholar who is, I think, fair to say, polymathic in her interests, as reflected in the book that, of course, underpins the theme of the lecture tonight. Now, before I introduce our speaker, who, of course, is well known to most of you, let me just say that following the lecture this evening, there will be a chance for questions. And I'm told that questions are going to be collected in a new way. There is a QR code. Now, somewhere near you will be this code, and I think it's going to be up here on the screen as well at some point. The code will prompt you to enter your question electronically, and that will then be conveyed to Carol Hinchcliffe, who is here, our librarian in the law school, and Carol is going to facilitate the Q&A using the questions gathered with the code. So, let's hope the tech is up to the task. If it fails, well, we can just put our hands up. The lecture's being recorded also, and the recording will be available on the law school website shortly. Now, this Rare Books lecture series has been going for 21 years. This is the 21st such lecture. And it began in 2002 as a way in which to showcase and celebrate the law library collection and to generate discussion and academic interest in that collection. Over the course of time, it's moved from one topic to the next, and this evening it arrives at Katy's abiding interest in animals and the law. Professor Katy Barnett, my colleague here in the law school, is, I think, best known academically for her work as a private law expert, in particular in the law of remedies, where she's one of the world's leading scholars on that, in that field. Perhaps less known until recently is the interest in animals and the law, which in recent years generated a research collaboration with Professor Jeremy Gans, who's sitting here in the front row, trying to look inconspicuous, but there he is. And they have collaborated to write this wonderful book with the memorable title, Guilty Pigs, a history, the weird and wonderful history of animal law. And it is on this topic that Katy is going to address us tonight. Katy, looking forward to what you've got to say and to the questions, and it's over to you.
Right, I can be heard, that's great. So, thank you so much for that very generous welcome, Matthew. I'm so proud to be part of such a wonderful, vibrant, diverse law school, and I'm just astounded by the beautiful turnout tonight. It makes me feel quite emotional. So thank you all so much for coming. I also want to thank Carol Hinchcliffe because she came up with this idea over a year ago And despite my natural shyness, yeah, really, she managed to persuade me that yes, I can do this. And it's great to finally see it happen. So as Matthew said, this lecture is in part derived from my book written with Jeremy Gans, called Guilty Pigs, which was published last year by La Trobe University Press. For those of you who know me by my academic reputation, this might be surprising. What is a specialist in the arcane, but I must add, fascinating world of contract damages writing a book about animals? Okay, it's fascinating to me, all right? I can make it exciting for you too, but I won't. Okay. Those of you who know me know basically that I'm interested in anything and everything. So, let's talk about how I came to write this book first. Oopsie. How about I do it with this? Excellent. There. Ha-ha. So, how did we come to write this book? Given that Jeremy is a criminal lawyer and evidence lawyer, I'm a private lawyer. Well, we were the erstwhile editors of a blog called Opinions on High, which dealt with High Court cases. That's the apex court in Australia. In 2015, the High Court decided a case called Knox City Council and Isbester, and it involved a Staffordshire Terrier named Izzy. There she is. Poor Izzy had been placed on death row, as it were, for her alleged role in a dog attack. Jeremy and I were fascinated by this case, and as it went through the court, we kept following what was happening to this dog. Anyway, one day we went and had lunch, and we started talking about all the animal cases we knew. Gosh, said Jeremy, we could almost write a book about this. Famous last words. Actually, I've always wanted to write a book about animals and the law, I said. And one of my friends who's here tonight, Dave, had always been urging me to write a book about animals and law for 10 years at that point. So we began to write the sections which later turned into parts of Chapter 4 and Chapter 7, and I put together a pitch. So far, so good. A former student approached a publisher for whom he had worked with the pitch. The publisher rather rudely said that it was not in the least interested. We were somewhat crestfallen and we thought, okay, that's that. Shelved the idea. Okay. So that was 2017. By 2019, academic publishing was in the news again. I got into a fight on Twitter with an academic. I'm sure no one can imagine either me or Jeremy ever getting into a fight with anyone on Twitter. Anyway, this academic said, justify your statement about the state of academic publishing. And I said, well, I can give you an example. Jeremy and I had a most excellent idea for a book about animals and the law, and we were rejected very rudely, and I think it's sad because it was a great idea. And then I closed Twitter and I wandered off. Ding, went my email inbox. Ding. Several publishers said, we're interested. So, really luckily for Jeremy and I, Chris Fake of Black Ink read my tweet and his curiosity was piqued. He asked us to send him our pitch and the sample chapter. So I said to Jeremy, it's back on. And he said, what do you mean it's back on? And I said, we've got to go through that pitch again. So we reassembled it and sent it through. And therefore our pet project found a home. So what I'm going to do is use the story of Izzy to tell you a little bit about the law, and then what I'll do after that is I'll go through some particularly interesting instances, but there's a whole lot of other things in there that you can ask me about, which I'm more than happy to talk about. But me being me, I decided to make a diagram of how the law works, all in one page. Okay, it's got many, I'm sure people can quibble with it, but how the law works, it can be made by decisions of judges. And because we've inherited law from the English, we've got both common law decisions and equity decisions. Equity is one of my loves, and my equity lecturer is in the front row. So, anyway. So the other thing we have is parliamentary legislation. So, and then underneath all that, we've got all these different kinds of law. So let's use the situation of Izzy to explain a little bit about how this works. There are many different... So, in August 2012, the Edward family went for a walk in the basin with their border collie puppy. They saw 3 Staffordshire Terriers roaming the streets. Later, the dog set upon the puppy and bit the puppy. While Emily Edward screamed, Jennifer Edward tried to pull the dog, which had latched onto the puppy, and, very importantly, her finger got torn. The local butcher and a passerby successfully pulled the Staffordshire Terriers away. Jennifer was left with a rip and a puncture to her finger, and she had to go to the doctors and get it bandaged. So, the 3 Staffordshire Terriers belonged to a woman called Tanya Isbester. They were ordinarily closed up in her back garden, but on that occasion, they'd escaped. This raises issues of private law, which is my speciality, questions of individuals' legal rights against other individuals, right? So it involves property law, who owns that thing, tort law, did the person do the wrong thing, and contract, which is agreements between people. So this incident might have involved questions of private law. The areas which might have been relevant here is tort law and property law. Well, property law was relevant in a way that I'll explain. Isbester owned Izzy. I expect if you're not a lawyer, you haven't really thought about what it means to own an animal before. What does it mean to say that you own something? Because she owned Izzy, she owed certain duties in regard to people with the way that she looked after her dogs. So she might have been liable in tort. Tort is an area of law which deals with wrongdoing. It's Norman French, like so much of the old common law. So she might have been liable in negligence for failing to lock up her dogs with care, and she might also have been subject to a tort called scienter, which is of medieval origins. That tort would have made her strictly liable for any injury caused by the dog bite, but only if she knew that the dogs were dangerous, or if it was an intrinsically dangerous animal. It wasn't. Dogs are not. So at that point, importantly, at that point, she did not know the dogs were dangerous. The concept that we own another living creature is an unusual one. And if there was a theme to this book, it was that the law struggles with how to categorise animals. Animals are not just a thing like a table. but they're not a person either. And so what happens with the law is that it oscillates between treating animals like people or things or something in between. If you own something, it means you can control it, you can destroy it, you can sell it, you can do various other things with it, and you can exclude others from it, subject to other laws. Now, was it a problem that the butcher had pulled this dog away? No. In this case, there was actually a parliamentary law. Statute, the Domestic Animals Act, empowered people to pull away an unaccompanied animal, and that's passed by the Victorian Parliament. Actually, any discussion of private law is hypothetical. No one sued in tort. The Edwards did complain about the dogs to the council, but nothing was done at that point, at least not until a later incident. In June 2013, the two male dogs, Bud and Jock, escaped twice. And they attacked several other dogs and their owners in two separate incidents, causing serious injury to the other dogs and to one of the owners, like really very serious. After this, Jock was put down because he was the common feature in all the attacks. And there you see, Isbester didn't have to ask anybody. She owned Jock. She could put him down. But it was after this that Knox City Council became involved and also turned its mind to the 2012 incident because it looked up, do these dogs have a history? Yes, they do. There was an incident last year. So it is then that the criminal law and evidence law was engaged, Jeremy's speciality. So Section 29 of the Domestic Animals Act makes it a crime for the owner of a dog to possess a non-dangerous dog which caused death or serious injury to an animal and a person. You might be thinking, hang on a minute, is a tear on the finger a serious injury? Well, that's where you've got to go look what the definition is in the Act. Yes, it's a serious injury according to the definition of the Act. So, by letting her dog bite Jennifer Edward, Isbester had committed a crime. So often what happens with crimes is you go before the judge or the magistrate and you come to an agreement. You plead guilty to some offences and they drop others. That's actually what happened here. So Isbester pled guilty to 20 offences under Section 29. There's an important point. The council insisted that Isbester acknowledge Izzy had bitten Jennifer Edwards' finger, although it's actually not clear that she had. As a matter of evidence, we still don't know really what happened. So the magistrate sentenced Isbester to a 12-month good behaviour bond. He indicated he would have jailed her if he could have done. And the council said, we're not going to seek Izzy's destruction from the magistrate. Note those words, not from the magistrate. They didn't. They then took Izzy before a panel of council members. So that brings up a third area of law, public law, which deals with the powers and decisions of governments about the people they govern. Constitutional law deals with the limits on government power, but this case raised administrative law. In making a decision about people and a dog, had the government behaved fairly in exercising its powers? A panel of 3 council employees decided that Izzy should be destroyed. Isbester then sought judicial review of the decision. So what you can do if the government makes a decision is then go to court and say there's something wrong with this decision. And that's actually how it got up to the High Court of Australia. Both the Supreme Court of Victoria and the Victorian Court of Appeal decided that there was nothing wrong with the way in which the decision had been made. but the High Court disagreed on just one basis. One of the members who decided Izzy's fate had also been the same person who investigated the incidents in the basin. She had no actual bias against Izzy, and there was no suggestion at all that she had behaved improperly. The issue was one of apprehended bias, simply that it might be perceived that she was biased even though she wasn't. So, the decision was set aside. Administrative law remedies tend to be of that nature, and the council was ordered to make the decision again. So a lot of non-human animal law is an application of human law. Did the High Court discuss Izzy much in the decision? No. It discussed her only once, when it described Tanya Isbester's particular interest in her dog's life. They said, whether one describes an interest in a dog as a property right or acknowledges the importance of a domestic pet to many people, the appellant, that's Isbester, is a person who may be affected by a decision which will require her interest to be subordinated to the public interest. So the judge's ambivalence over whether Izzy was Isbester's property or something more came up over and over again. Strikingly, it didn't actually matter in this case to the judge's decision. Izzy wasn't returned to Isbester, despite her pleas. A different panel decided that she should not be destroyed, but she was passed around various RSPCA offices in Victoria, South Australia and then Queensland. She was apparently a very good girl. Eventually, a couple decided to adopt her, having been fully told of her history. And when they discovered we were writing this book, they actually got in contact. And they said, do you want to know what happened to Izzy now? Yes, I did. So the picture before was rather sad. Okay, the picture they sent me of Izzy, you know how dogs do that thing of that's how Izzy was. It was so beautiful that I just burst into tears on the spot. So Izzy is now living a very happy life, running around on farms, being a very good girl, and has never had any other problems. So there is a happy ending to her story. So that's just a start of how one case can actually bring up the whole of the law, right? Private rights between people, criminal convictions, evidence law, how the government behaves towards people. But it also brings up this question of what is our relationship of animals with animals, right? I mean, after all, we're animals too. We use the terminology animals, human animals and non-human animals, right? And a lot of times the cases actually show us more about us than they show us about animals. So now what I'm going to do is discuss a couple of the things that we talk about in the book, and then finally I'm going to discuss some things that came up after the book was written, and then we can talk about it afterwards. So you might be wondering where the title of the book came from. Well, along with my many other interests, I have an interest in medieval and early modern history, and I've known for a while of a very strange phenomenon when 13th century courts in what is now northeastern France decided to prosecute pigs for crimes. When I mean prosecute, I really mean arrest them, interrogate them, put them in the dock, no, I'm not kidding, make them give evidence. They were judged on whether they were well behaved or not. And then sentence was passed. They were given counsel. So it was taken very, very seriously. Later, this phenomenon spread right across Europe. Not just France, but it was still predominantly France, but also Germany, Sweden, Spain, and it spread to other animals. Cows, horses, donkeys, sheep. All of these animals were actually prosecuted. Okay, what for? You might be wondering. Okay, murder. Quite often, they arose when an animal killed someone. Particularly, I'm afraid, when they killed a young child. So, you might be thinking, why on earth would this phenomenon arise? Well, in psychological events, if a child dies, it's what's called a moral event. It creates a certain emotional response. You're horrified, right? It's been shown that if an animal does something which is either particularly horrible or particularly wonderful, we start to treat them like people. We personify them. And so there is a pigeon, for example, called Cher Ami, who received the Croix de Guerre for his or her bravery during World War I in the face of German fire. It obviously was a very brave pigeon. You might think, well, this is really strange. Why did people do this? Well, I want to suggest we're not so different to that now. Sometimes people treat, firstly, things like they're animate. You might say, oh yeah, right. Actually, medieval law, they had this thing called deerdans where they would sue buckets, pieces of rope, things like that. I'm not kidding. We can talk about that later. But you might think, well, that's mad. Okay, have you ever hit your printer and shouted at it? I bet you have. It's a moral event where you actually feel quite angry. In the book, I looked at some research by Goodwin and Benferrado, a psychologist and a lawyer, who gave people hypothetical newspaper articles about sharks attacking people. The response of the people depended on whether the victim was a child or had committed a heinous crime. So if the victim was a child, basically people responded incredibly punitively. They wanted the shark to be killed. They wanted that shark to be killed painfully. Another shark was no good. And they really wanted that to happen. Whereas if the shark killed a heinous criminal, well, they didn't care so much. They were just a bit like, well done, shark. So the response depended upon who the victim was. This actually kind of goes back to biblical law. Think of an eye for an eye, a tooth for a tooth, right? And we ended up tracing this right back to biblical stipulations about vengeance and also the passage in the Bible about the goring oxen. Because as far as we can work out, that's where this idea that animals should be put on trial came from. It actually comes originally from the Bible, from the book of Exodus. While most societies don't try animals like they are human, there are a minority who do from time to time. And then when we actually looked at modern cases, we did find that they sort of slide into this thing of, was the dog's behaviour reasonable? Was it a reasonable cow? I'm not kidding. So perhaps we're not so far from the people of Normandy as we think. Okay, so the next situation is involves custody dispute of a dog. Actually, I found a lot of family law cases involving pets because the whole problem is the Family Law Act treats them as property, but the people don't see them as property. Therefore, it's actually really difficult. And obviously, you can't divide up a dog or a cat or a... So, when King Solomon faced a dispute about who was the mother of a baby, he threatened to divide the baby in half to make the parties reveal their own relationship to it. And Solomon wisely awarded the baby to the woman who immediately dropped her claim. But what happens when ownership of a dog is at issue? Well, courts struggle, but in one New York case, it's Washington DC case, the judge came up with a novel solution. Judge Edward Kimball was faced with a dispute over a white fluffy dog where the two parties were arguing that they both owned the dog. So hat shop owner Keely Moore said that the dog was Prince and that he bought him off someone on the street. Miss Helmick, who had passed the hat shop and found the dog, there said, no, that's my dog Buddy. He was stolen from me. So, the Washington newspaper reported the judge's solution as follows. "And now call the dog," His Honour commanded the court officer. The animal had been held in confinement in Judge Kimball's private room while the testimony was being taken in the courtroom. In another moment, the court officer, that would have been me back in the day, returned leading the dog by the collar. Officer and animal approached the witness stand, and suddenly the dog's ears rose and his nostrils quivered as he evidently caught a scent which was familiar and grateful to his keen senses. With a turn of his head and a swish of his tail, the animal bounded to the chair where Mrs. Helmick sat and, raising his forepaws to her knees, pressed his nose to her cheek and licked it, while the delighted animal continued to wag his tail with enthusiastic joy. Mrs. Helmick got the dog. Judge Kimball, in fact, pronounced the evidence unequivocal. However, Moore later told the newspaper that he planned to appeal, saying no evidence was offered to identify the dog other than mere say-so. Actually, he's right as a matter of evidence law, as Jeremy pointed out to me. While the Helmick family gave evidence under oath and were cross-examined, the dog wasn't. Alas for Moore, the hearsay rule doesn't apply to animals. It only applies to human witnesses, not non-human animals, and so Keely Moore lost Prince. And I really don't know what the truth of it was. So, there you go. But one of the other things we looked at was, can animals give evidence? What about sniffer dogs? Turned out to be really difficult. What about all those apocryphal cases where parrots swear at people or talk about murder? We'd never found a case where they were actually taken in evidence. Okay. Right, now we get to another interesting medieval bit, which is swans. So, did anyone ever hear that thing, oh, the Queen owns all the swans, right? Or the King now. Although, I'm sorry, I still have great difficulty. I suppose it's been my whole life, the Queen. Okay. Anyway. The truth is actually stranger than that. It's my 15 seconds of fame. The New York Times called me to ask me, did King Charles III own all the swans? I said, you don't want to talk about contract damages? No. What can you do? So the truth is, King Charles III could, if he wished, exercise his royal prerogative to claim all the unmarked mute swans of the genus Cygnus olor in English and Welsh waters. Okay, so mute swans are a particular one they have a little bit black bobble at the end of their nose and they're white. And they don't make much noise. They do make a noise, they're not actually totally mute, but they don't make much noise compared to other swans. I did suggest to the New York Times that if His Majesty wished to consult me, my fees were reasonable, but I never heard back. So again, this is a medieval thing. It dates back to medieval times. Very bizarrely, in England, ownership of swans became a status symbol, like having a yacht or a Rolex or something like that. The medieval equivalent was owning swans. No, I'm not kidding. So, the first mention of it is actually by Geraldus Cambrensis, or Gerald of Wales, who said, well, obviously the king owns all the swans. Obviously? Okay, fine. Why? We don't really know, other than they're kind of beautiful and stately. Although one of my friends calls them pretty geese, because they can be. I've been chased by one in Cambridge before, but I just wish to note this. But then people started to say that they own swans too. And in order to claim ownership, how do you own a swan? How do you show it's your swan? Well, you put a mark on their beak. Seriously. So people started putting marks on the beaks of swans, and this was called signota in Latin. And this became so popular that in 1361, Thomas de Russum was given responsibility by the king for the supervision and custody of all our swans, as well as in the water in the Thames, as elsewhere within our kingdom. And from that day onwards to the current day, the king has had a master of the king's game of swans, also known as the Royal Swan Herd, the Royal Swanherd, which is my favourite, or the Royal Swan Master. And he wanders around with a big swan feather in his hat. Someone saw him and took a picture of him for me. So, a declaration in 1405 reiterated that only the king could grant people swan marks. And until that time, ownership of swans had been governed by customary law. And the Swan Master also had an obligation to keep the swans safe in inclement weather and when there were storms. I don't know how the Swan Master was supposed to do this. I imagine him running around with umbrellas, but... In 1482 and 1483, Edward IV actually passed an act for swans. Why? Well, the lower sorts were starting to own swans as well. Yeomen and husbandmen and other people of little reputation. Therefore, he passed legislation to say that the only people who could have swan marks or own swans were noble and rich people with a certain amount of land and money. And those who were disqualified had to divest themselves of ownership by Michaelmas, and then, if they didn't do so, those who were entitled to ownership of swans were entitled to seize them. So I'm kind of imagining these people seizing swans. What the heck's going on here? Okay, this is what's known as a sumptuary law. A law restraining someone from owning or consuming or wearing something based on social class and social hierarchy. So in medieval times, there were also laws at different times which were not very successful about what colours people could wear. You know, if you're a peasant, you can only wear brown, only the king can wear purple because that's expensive. only the king can own swans and only the king can grant right to swans, so on and so forth. So it's designed to show that you're kind of powerful and rich. In 1247, in fact, Henry III ordered 40 roasted swans for his Christmas celebration at Winchester. And at this time, they started formally registering swan marks in books. This process was called swan-upping. So what they did is they had huge books. So I got this, actually. I went and consulted all these books. They're huge. People marking down, this was my swan mark, that's his swan mark, that's like years and years and years of swan marks. It's actually the beginning of trademark law. I'm not kidding. It's the first trademark. Really not joking. So the marking, recording and disposal of swans was known as swan-upping. Apparently you have to do it at the time when swans are molting, because otherwise they bite you. Well, they bite you viciously anyway, but they can't fly away. And then you mark them and you note them down, and you record who owns what. And it became so popular that the king formed special courts of swan mote or swan moot. No, I'm really not joking. In 1592, some brave nobles decided to challenge Queen Elizabeth I for the ownership of unmarked swans at Abbotsbury Swannery. They had been owned previously by a monastery, but that had been dissolved by Elizabeth's dad. The court confirmed, possibly unsurprisingly, that the unmarked swans belonged to Her Majesty, and explained also that the ownership of cygnets was different to other baby animals. So usually with baby animals, whoever owns the mother animal owns the babies. Not so with swans. One goes to the owner of the father, one goes to the owner of the mother. What if there's an uneven number, you ask? Aha! Lord Justice Cook said, in that case, the uneven number goes to the person upon whose land the nest is. Actually, swan-upping still happens to this day, and I basically have people who take photos of this for me and send it to me, which is very kind of them. Hello, those people. But they don't do any of this marking stuff anymore. It's actually more conservation now than some kind of weird status symbol. I did look up the Queen's website, and it did tell me explicitly that Her Majesty, when she was alive, did not want to claim the swans, although she is quite fond of the ones around Windsor Castle. So, there's also this thing, the Queen has the right to eat swans. Actually, no one is allowed to eat mute swans in Britain now, as they're protected as a wild bird under the Wildlife and Countryside Act, and it's an offence to eat one. However, King Charles III could probably eat swan if he wanted to, but that's only because of sovereign immunity. It's not because of any deeper principle. And it kind of pleased me that the King's prerogative does not extend to the Australian black swan. Hence, we actually introduced some black swans to England and they've gone feral there. Ha ha! Bite a bit. King Charles can't have them. Nope. They're the wrong species. Cygnus atratus. Unowned. So, okay. So that's the strange law of swans. I could probably talk much more about that, but I'm going to get on to the octopus selfie because that's rather fun too. So, while we were writing this book, in 2020, the winner of the Underwater Photography Guide competition was a Sydney academic engineer called Gaetano Gargiulo for this photo. Jeremy and I could see only one, well, actually probably three problems. We're lawyers, that's what we do. We see problems. Gargiulo had not taken the photo. What had happened was that the octopus had come out of its little den. Gargiulo had put the waterproof camera in the water. The octopus had taken the photo. So it's actually an octopus selfie. In our book, Jeremy and I had already discussed the difficulties of the selfies taken by the Sulawesi macaques, the monkey selfies. You might recall them. It's kind of these little black-haired macaques going, obviously quite enjoying taking pictures of themselves. A dispute arose when the owner of the camera was sued by People for the Ethical Treatment of Animals, or PETA, in an attempt to claim copyright on the photos on behalf of the monkeys. Ultimately, the United States District Court for Northern California decided that first, PETA did not have standing to represent the monkeys, in part because it could not know what they wanted. Did monkeys even care about copyright? If they did, what did they want out of it? I don't know. But secondly, the US Copyright Act had things like grandparents and things like that, so it obviously contemplated that what was involved was human animals, not non-human animals. Such an argument wouldn't even be possible in Australian law because our Copyright Act explicitly contemplates that authors are persons. But there was another issue Jeremy and I thought about. Was Gargiulo really the winner of the prize at all? Was in fact the winner the octopus? Should it been the octopus who had a 7 nights liveaboard diving package for one to the Solomons? I mean, seriously, the octopus took the photo. Actually, this is a contract law question, which concerns the promises people make to each other. When you enter into a prize, you enter into a contract. And it might also turn on consumer law. Chances are that we could have resolved this by looking at the actual rules of the competition, because by entering into it, you're bound on it. So we did have a look. All photographers are eligible. Said nothing about humans, including amateur, semi-pro and professional. No mention of octopi. Okay, you must have been in the water when taking the photo. In the water. And all judges' decisions are final. Of course, all this will only matter if someone, and it has to be a human someone, decides to sue on behalf of the octopus. Finally, there's a third difference. Okay, so most of our chapters we have a running example, and in most of them, they're mammals, right? But Jeremy and I thought, there's another, really intelligent animal which is not a mammal. How many cases are there about octopus and cuttlefish? It's really the best fun you can have as an academic. I'm not kidding. So, an octopus is very different to a macaque, right? Perhaps, unsurprisingly to anyone other than Jeremy and I, who really did our best to look, there weren't many cases involving octopuses, despite how intelligent they are. Our laws is skewed by the sorts of interactions that have ended up in court to date, something that's largely determined by human interests and desires. There weren't many cases about insects either, apart from, some French weevils being sued. No, they were anathematised in medieval times, but there really wasn't that much involving insects either. So basically our law is skewed by what humans see as important, not necessarily by what animals exist or what animals are important. This leads me on to the final part of the discussion, matters which weren't discussed in the book. So, unfortunately, after the book was out, A decision came down regarding Happy the elephant. There's a group of people known as the Non-Human Rights Project, and it's their aim to give animals legal personhood, right? Their argument is that corporations are not real people, yet we allow them to have standing before the law and to be legal persons. Why not animals? So they bring actions on behalf of animals, and in this case it was Happy the elephant. She's kept at Bronx Zoo. I checked yesterday. She's quite elderly now, but she still seems to be about. She was born in the wild in 1971, but has been kept in captivity since she was very small. Now, we actually have laws regarding the imprisonment of humans, right? We can seek a writ of habeas corpus against a government who illegally or indefinitely imprisons us. What the Non-Human Rights Project tried to do was seek a writ of habeas corpus on behalf of Happy, saying that she had been illegally imprisoned. And they argued that she should be given the rights of a person, given her autonomy and cognitive complexity. She's like us. She can recognise herself in a mirror. She can draw, that kind of thing. A majority of the New York Court of Appeal decided in June 22 that the writ only extended to human animals, not non-human animals, and that if personhood was to be extended to animals, it was a matter for the legislature. Justice Wilson and Justice Rivera dissented, and they would have granted Happy some legal rights, even if she was an elephant. Actually, apparently Happy isn't a very cheerful elephant. She doesn't like the other elephant. That's why they're separated, Patty. They like to be near each other, but not in the same thing. Anyway. There were 7 of them originally after the 7 dwarves, and poor Happy got called Happy when she is a grumpy. Anyway, she doesn't have legal personhood. But you'll note the court said it's for the legislature to decide. Well, in Panama in March 2023, the president of Panama passed legislation protecting endangered leatherback turtles. The legislation gave sea turtles the right to an environment free of pollution and other human impacts which cause physical or health damage to them. The most interesting part for me, however, was that the legislation specified that sea turtles, as living creatures, have rights, and that those rights can be enforced by people who bring lawsuits on their behalf if their rights are violated. So if the turtles are harmed or there's people trying to poach them, a person can actually go to court and get it stopped. Why did they do this? Well, they said we had animal protection laws and they weren't working, so we actually need a person to come to court. Well, what happens next in the weird and wonderful world of animals in the law? I'm not actually sure, but I'm sure that whatever happens, it'll be interesting. And so now we come to the end. I just wish to say none of this would have been possible without the marvellous Carol Hinchcliffe. In lockdown, she hunted down all kinds of bizarre things, including some kind of Pennsylvanian ethnology thing about elephant trials. She's amazing. Consistently passes on things even now. Thanks especially to Jeremy for getting on board with the project and putting up with me as a co-author. Thank you to my family. Hello. For listening to the 500 billion random animal facts that I come out with on a regular basis. And thank you to Matthew for hosting tonight, to the media team, to the Law Library, and to all of you for coming. I'm just delighted that you were here.
Okay, thank you so much, Katy, for delivering our 21st Law Rare Book Lecture. You have educated us, you have entertained us, and I can't wait to see more of your adventures of research with Jeremy as you explore developments in animal law. We have a number of questions. I've got a short one here. Are there any hypothetical interactions between animals and the law that you would really like to see play out in the future?
Oh, that's an excellent question. Well, actually, I wouldn't mind with those turtles seeing someone sue on behalf of the turtles. I'd like to see how that worked. I hope it actually does work to help the turtles. So that's the first thing I can think of. Yeah, I think that's what I would be really interested to know, is giving people standing to represent the turtles, does it actually make a difference or not? Maybe compare it with another area where they don't have it.
Okay, all right. Hold that thought. You'll keep thinking about that one, I'm sure. Okay, we have an audience member who's curious about your view on the potential impact on sea animals that may be caused by the release of the radioactive wastewater by Japan.
Yeah.
Is there any legal issue that would or should arise? And is there any international law that would cover this, especially in relation to the protection of the sea animals?
So, basically this is a question of international law. It involves the kinds of treaties that people get into. One of the difficulties with international law, which you can kind of see with the Ukraine conflict, is the court says, no, you can't do that. And then what happens? Nothing. Because they make a declaration and there isn't actually anything you can do about it. Probably the way in which that would be dealt with, though, I'm wondering if it would be dealt with under the World Trade Organization or something like that, because that's the kind of area where it tends to have teeth more, and where the remedies actually tend to kind of have effect. But they would probably have to do it. Actually, Christine and I have a PhD student who's... I should also thank Christine, Christine Parker, hello, who set up a whole reading group for us. It was actually basically what we dreamed of when we thought we were getting into academia. And it never really happened apart from this, so thank you, Christine. But we have a PhD student who's looking at how people use the WTO to deal with animal disputes. So seals, dolphin-friendly tuna, that kind of thing. It's that kind of thing which is likely to have more of an effect than the treaties and things like that are kind of more aspirational. So it probably does raise some legal issues, but you'd have to show, firstly, that it caused harm. Secondly, that it was beyond what the natural amount was anyway. My understanding in some areas of the world is that natural radioactivity is quite high. And then you'd have to work out how to enforce it in a court. So that's my answer. But
okay.
Yeah.
Well, thank you very much. We are reaching 7 p.m. and there are a couple of questions here, and I'm sure if those people would like to come and have a quick chat to Katy afterwards, she will answer their questions. So I just want to thank you very much, Katy. You've done an amazing job. And I want to thank you all for coming this evening. And the Melbourne Law School events team have done an incredible job in getting us organised this evening. And thank you to our Dean, Matthew Harding, as well. So we have a small gift for you. And thank you very much, and we hope to see you here back at Melbourne Law School for an amazing series of lectures, public lectures that occur throughout the rest of the year as well. So thank you and good evening.